Now we'll discuss the very problem of ninth or the ninth problem, and that is A, who is Biz Muktia, promises to exercise his influence as such with B in favor of C, and C promises to pay Rs 1000 to A for it. A acts on the promise, but C commits a breach of promise to pay. So advise A. So here A is helpless as because the consideration is not lawful. As such, the contract is voidable and she is at liberty to pay Rs 1000 or not, and the agreement is void because it is immoral, and the very problem as per the provisions of Section 23 of the Indian Contract Act is voidable. And now we'll go to the problem of number 10, where A agrees to sell 100 tons of oil to B but fails to do anything further in the matter. So advise B for the very action against A. So as here A agrees to sell 100 tons of oil to B, but other conditions regarding description, quality of oil, time of payment and delivery, etc., are not given. Hence, the contract is void for uncertainty and vagueness within the meaning of Section 29 of the Indian Contract Act. And now we'll go to problem number 11. So here, according to the very problem, A leaves a cow in the custody of B to be taken care of C, and as a calf, B returns only the cow to A and retains the calf for himself. So advise A. The problem is based on Section 163 of Indian Contract Act, which reads as under: in the absence of any contract to the contrary, the belly is bound to deliver to the bearer, according to his direction, any increase or profit which may have accrued from the goods belt. Therefore, here, where A leaves a cow in the custody of B to be taken care of, and C has a calf, B is bound to deliver the calf as well as the cow to A. And now we'll go to problem 12, and that is B and P, two wrestlers entered into an agreement to wrestle at Pune at a fixed date. They also made a condition that if any party failed to appear, we should forfeit Rs 500 to the other. P failed to appear in the ring, can be recovered Rs 500 from him. So, yes, we can recover the money in the absence of P because the conditions of the contract should be followed according to the provisions of section 47, as if not followed he is liable for damages. And now we'll go to the problem, that is the problem number 13. A minor borrows Rs 500 from B and executes a promissory note for the amount in favor of B. After attaining majority, A executes another promissory note for the same amount in favor of B. In settlement of the first one, B sues A on the second promissory note. Will he succeed? So, as to the very problem here, B will succeed because the second promissory note written by A in confirmation of his first promissory note as executed when he was minor, but on attaining majority he executes the second promissory note. So such promissory note is valid. And now we'll go to the very problem, that is the problem number 14. Here, A's son had absconded. A instructed his servant to trace the boy. Subsequently, he offered a reward of Rs 500 to anybody who found the boy. The servant found the boy, but he did not know of the offer of reward. However, when he came to know of it, he claimed it. Is he entitled to do so? Gives reasons. So, here the servant is not entitled to get a reward because the proposal of reward came to his knowledge after finding the boy by him, and the very fact of this problem is similar with the case of Longman versus Gauri Dutt of 1930, which was decided by the Allahabad High Court. And as to the very problem regarding the very question that is of number 15, we'll discuss in our upcoming video. And the very problem is that A residing in America authorizes B an advocate in India by a power of attorney to sell his property situated in India and to execute the sale deed and to present it for registration. Be executed and got the sale deed duly registered in his capacity as the power of attorney of A. Subsequently, the sale deed was challenged on the ground that it was legally invalid as the power of attorney, on the strength of which it was executed and registered, was defective. A thereupon executed another power of attorney in favor of B for the same purpose. After duly removing the defect in the earlier power of attorney, what will be the effect of the second valid power of attorney on the earlier and on the sale deed executed and got registered by V for and on behalf of A, and this solution for this problem we'll discuss in our upcoming